Natural law is a universal system of legal and moral principles that derives not from legislative or judicial enactment, but from the nature of being and conscience itself. Natural rights are rights that exist independently of any government or institution. They include, but are not limited to, the right to life, liberty, and property. These rights are inalienable and absolute. They cannot be surrendered, transferred, or diminished. These rights are now codified and expressed in binding international instruments, namely the International Bill of Human Rights, which includes the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, ICCPR. Most states, including Canada, are signatories to these covenants and are under binding legal obligation to respect, protect, and fulfill the rights listed within them. The rule of law as defined by international legal standards. This requires that all state parties ensure and respect the exercise of rights recognized in the ICCPR and ICSCR. Article 2.1 ICCPR. Where necessary, states must take legislative or other steps to give full effect to these rights. Article 2.2 ICCPR. No state or actor may limit or destroy the rights and freedoms recognized in these covenants. Article 5 ICCPR. Any such action is a violation of peremptory international law. In Canada, they must apply these principles in accordance with the Constitution Act 1982, especially the Canadian Charter of Rights and Freedoms, which expresses Canada's obligation to uphold international human rights law. The Charter applies to all levels of government and overrides contrary domestic enactments. Constitution Act 1982, Section 32. The Supreme Court of Canada has ruled that the common law must evolve in alignment with Charter values. M.A. v. Ryan. The Charter is not merely a domestic law, it is an instrument of international human rights expression. It gives effect to the same natural rights and peremptory norms that bind all governments under international law. The executive and legislative arms of government must conform to these obligations. No sovereign, no government agent, and no law may override the rights declared in the covenants. The Charter of Rights and Freedoms express international law, which in turn respects and ensures our natural rights and freedoms. The executive legislative powers that are in operation must respect the obligations flowing or coming from the Charter. Thomson Newspapers, Lieutenant v. Canada, Director of Investigation and Research, Restrictive Trade Practices Commission. While individuals, as a rule, have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent to the organization of the state, and he owes nothing to the public. Under international law, these fundamental rights and freedoms have, since 1976, found their expression in the International Bill of Human Rights, including the ICCPR and ICSCR. Countries who are signatories to these covenants are under legally binding obligation to respect, protect, and promote individual human rights and freedoms listed therein. As with any obligation, responsibility cannot be imposed upon a person unless that person is aware a liability exists. Individuals must be made aware that states are bound by these obligations. The rule of law, which states that governments must ensure that individuals can exercise their fundamental rights. These rights include those enumerated in the International Covenant on Civil and Political Rights, ICCPR, those enumerated in the International Covenant on Economic, Social, and Cultural Rights. The following principles: ICCPR Article 2.1. Each state party undertakes to respect and ensure to all individuals within its territory and jurisdiction the rights recognized in the covenant. ICCPR Article 2.2 states must adopt laws or measures to give full effect to these rights. ICCPR Article 5, no state, group, or person may engage in any act aimed at destroying or limiting these rights beyond what the covenant permits. No government agent, executive power, sovereign, or even monarch may lawfully perform any act that destroys or limits the rights recognized in the international covenants. The Constitution Act of 1982 expresses the fundamental human rights and freedoms applicable in Canada. The Charter is the mechanism through which individuals express and defend their rights. The Charter reflects binding international obligations. Domestic laws, when they enforce mandatory corporate personhood upon natural persons, violate the rule of law. In Canada, numerous provincial statutes enforce involuntary incorporation, thereby subordinating natural individuals to statutory fictions. Ontario Municipal Act. The inhabitants of every municipality are incorporated as a body corporate. 2017, C20, Sked 8, ST 99, 1. New Brunswick Local Government Act, Section 4, 1. The residents of a local government created under this act are incorporated as a body corporate. Section 199. Continuation of corporate status regardless of inconsistency with new legislative structure. Alberta Municipal Government Act, Section 4. A municipality is a corporation. Legal effect. These provisions force natural persons into artificial legal identities, thereby violating the individual's right to recognition as a person before the law under Article 16 of the ICCPR, a non-derogable peremptory norm. Courts, governments, and all officials, regardless of office, jurisdiction, or authority, are fully and strictly subjected to the rule of law. This is affirmed in Canadian constitutional jurisprudence and in binding international law. Constitution of Canada, 1982. Preamble affirms that Canada is founded upon principles that recognize the supremacy of God and the rule of law. Christie Viz, British Columbia, 2005. The rule of law, a fundamental principle of our Constitution, must mean at least two things. First, that the law is supreme over officials of the government as well as private individuals and thereby preclusive of the influence of arbitrary power. R.V. Wagner, 2015. The rule of law finds itself in the preamble to the Charter of Rights. Its spirit is manifested throughout the document. It is part of the constitutional DNA of this country. International Covenant on Civil and Political Rights, ICCPR, Article 2.1 and 2.2. Every state party must respect and ensure the rights of individuals and adopt all necessary measures to give those rights full effect. This applies to legislators, executives, judiciaries, and municipal or statutory actors alike. Just Cogan's peremptory norms. These include the right to recognition under law, Article 16 ICCPR, which cannot be derogated, limited, or reinterpreted by any branch of government. Courts, Parliament, executive agencies, and municipal bodies are bound to operate within, under, and according to the rule of law, which is itself grounded in higher, immutable principles like natural law and human dignity. Any deviation from that is not just a policy error, it's a legal and constitutional violation. Courts are explicitly and repeatedly affirmed in jurisprudence as subject to the rule of law. Their duty is not only to apply it, but to uphold it against all other pressures, including the government, the legislature, or public sentiment. Here is some direct binding jurisprudence from Canadian courts. R.V. Peel, Regional Police Service, Chief of Police, 2000. The courts, too, must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. This affirms that even the judiciary must be held accountable to the rule of law, especially when constitutional rights are at stake. R.V. Wagner, 2015. Judges must stand against the winds and rains to uphold the rule of law. I agree that the rule of law is, quite apart from the terms of any written constitution, part of the constitutional DNA of this country, and that its precepts must be abided by and must be applied by judges, no matter how strong may be the prevailing winds. Courts cannot plead political difficulty or social pressure as an excuse to abandon the rule of law. Villadell v. Dunham, 2012. A constitution provides an added safeguard for fundamental human rights and individual freedoms. Constitutional entrenchment ensures that those rights will be given due regard and protection. Courts must not allow the state or themselves to override rights for convenience. This reinforces that constitutional rights and the rule of law are superior to legislative or judicial convenience. Board versus Board, 1919. If the right exists, the presumption is that there is a court which can enforce it. That alone is sufficient to give jurisdiction to the king's courts of justice. If a right exists, a court must exist to enforce it. No other process or absence of law can excuse denial. These cases confirm courts are not above the rule of law. They are its guardians, and any failure to uphold it, especially where peremptory rights are concerned, constitutes complicity in its erosion.